And I've just started the recording. This will be saved in the usual Rentman channel on YouTube, which you get to through the tutorials button on Rentman's help toolbar. All right, the numbers are climbing, so we're 1 minute past at the moment. I'll give it another 1 minute, and then we'll begin. Okay, right. So let's begin. There's still some yet to join us, but I think we have to begin. So welcome to everyone. We are recording this, and as I said, it will be available on Rentman's usual YouTube channel. There's a question and answer button below for you to answer questions, and they'll either get passed on to David as we go through, or Nick Sharp of Training for Professionals may be able to answer them as we go. So allow me to introduce David Dalton Gibson of Training Professionals. Rentman has used TFP's documents for more than 20 years now, and it's always David I've turned to for any legal questions that have come up in that time, both in terms of just lettings, contracts, agreements, but also GDPR. So thank you, David, for joining us today. Perhaps we should start. I know there was an announcement yesterday, so perhaps we could start with you updating everyone with the most recent developments and your expected timeline, especially for distributing new documents. That's the commonest question I get when you get new documents.
Yeah. Okay, so what actually happened yesterday was the final Commons sign off to the Lords amendments. So on the 14th, the Commons rejected a collection of amendments from the Lords, and it went back to the Lords. We thought they would. We didn't think the Lords would put up any significant fight, so ping pong didn't go on very long. Basically, they have given up on all the proposed amendments, things like an extra 3-week deposit for pets and those sort of things. There were, however, 2 further amendments that the government were happy to accept. And so those came from the Commons back to from the Lords back to the Commons yesterday. And formally yesterday was accepting those Lords amendments. So the House of Lords and the House of Commons have now both finished with editing of the Renters' Rights Bill. And we are now slightly in limbo waiting for what's called royal assent, where it gets the official King's approval. It's something of a formality, of course, because Parliament make the decision and the King just agrees. We don't know when that will be. There is no schedule for that. It literally could happen tonight. The King might open his red box and say, okay, yep, let's sign that one off and it's done. I believe he might be away at the moment, so it might be a little bit later. But we expect it to happen very imminently. We're literally, certainly by the end of next week, we would expect it to have received royal assent. Now, that's the point at which a bill becomes an act. So we'll then start referring to the Renters' Rights Act, not Renters' Rights Bill. There is one part of the act that comes into force on royal assent. So literally it goes live as the thing is signed by the King. And that is the power for the government to write regulations which bring in a lot of detail. So, very simple example, we know that we are going to have to give a statement to the tenants, both our existing ones as a sort of transition statement, but also all new tenants are by law going to need to have a new statement given to them. What we don't know is what's going to go in the statement. So what goes in the statement is what will be specified in regulations, and we are in the office here sitting on tenterhooks, literally watching, because as soon as it gets royal assent, then the MHCLG can then lay the regulations that give us a whole load of detail. And it's slightly worrying us that there's quite a lot of promotion around come and learn everything about the Renters' Rights Bill, when in fact, without regulations, there's a lot of stuff we don't know. In terms of
that's just guesswork, really, from other people who are saying they're ready.
What it is that they're talking about what's in the bill, soon to become the Act. We actually did most of that a year ago when the bill was first produced. We didn't wait until now because, the direction of travel was clear. The only amendments have been relatively small tweaks. I'm sorry to tell you that they're not going to allow you still to serve a Section 21 notice or keep assured short-hold tenancies. That was pretty evident. The government have a very large majority in the Commons. They can push through anything they want. So that was pretty much an inevitability. So we actually dealt with that a year ago because I think, and it's rather untalked about, some of the questions I know that you've shared with me will flag this up again when we talk about it. But I think, for example, renewals are going to die as a concept. People will no longer be doing renewals. Very simple reason. If you say to the landlord, I don't know, say you charge £500 to do a renewal, you're going to go to the landlord and say, look, your tenant's on a monthly periodic tenancy. Would you like to pay me £500 and I'll put them on a monthly periodic tenancy? Well, the landlord's going to go, no, I'm not. It's just the same as I've got already. And for that reason, now the reason we thought this is important a year ago is if you had a year to transition your business and work away from being dependent on the renewal income, then of course you had longer to do it. If that's the first time you're hearing of it now, then obviously you need to get on with that element quickly. And we've certainly done training. I did some training for quite a large agency who shall remain anonymous, but they have about 25 staff who run a whole renewals department. And they suddenly woke up and realized that they were all sort of going to lose their job. What we've suggested is that they will become, in fact, a rent increase department, because I think the whole process of rent increases is going to go up. It's going to become more cumbersome. And it's a charging opportunity as well, because there's more work to do. And this whole review of your terms of business is something that agents need to be doing. We've already, we're literally probably either, hopefully today, we will release our updated terms of business. So we've got rid of all references to assured short-hold tenancies or Section 21, because there's no reason not to update your terms of business now. Look at your charging. Do I need to make charges for things I didn't used to make charges for? Because now I'm not going to make any money out of renewals, therefore I need to charge for, say, Section 13 rent increase notices or negotiating them. I think the negotiating is actually the important bit. So these are the things that I think we could and should be doing. If you haven't done them yet, we need to be getting onto these as soon as possible. You asked about the tenancy documentation. I've had so much fun with this in Wales because we're going down a very similar route to Wales. Wales switched away from assured short-hold tenancies in December 22, and they now have what is referred to as a statement. So it is a legal obligation in Wales for an agent or landlord to give a tenant the statement. And that's exactly what we're doing in England. I was listening to an event last night which wrongly stated that we're going to have written tenancy agreements. That is not what the law says. It's that we have to give a statement. Now, let me start by explaining the difference because it's not clear. If you offer a contract, it's a chance for the tenant to say, yes, I agree, or no, I don't agree. It's a choice. When you serve a statement, they don't get that choice. I'm telling you this is what's happening. And what is going to happen going forward, we are not actually required to have written tenancy agreements, but we will be required to have a written statement. This is going to be really important around what I'll call the transition, because we've got hundreds of tenants already on tenancy agreements. And if you went out and said, would you all mind signing a new tenancy agreement? You would spend weeks trying to get everybody to sign it up. They're in the property, they're too busy, Christmas is coming up, and you'd never get it done. Because it's a statement, you don't need them to sign it. You can literally just send it to them. As long as you've got the evidence you did it, you're absolutely in the clear. So that's the difference between the tenancy and the statement. Having said that, what we did very successfully in Wales, and our plan is to do the same in England, is to combine the statement and the tenancy into one document. So it will be an agreement that we'll ask the tenant to sign, and they'll confirm, yes, I agree, I'll cut the grass and I'll clean the windows and I'll et cetera, et cetera. But it will also include all the statutory statement elements. The problem that we face is that we know the 6 things that are contained in the Renters' Rights Bill that the statement can talk about: the property, the tenant, the tenancy, the landlord, but we don't know any details, and those details will come out in the regulations. And this is why we're sitting on tenterhooks waiting for the regulations, because then we can start making some progress. So we are absolutely on it. We've started the sort of process our end for doing an update. We've incorporated some other updates that we wanted to do anyway. We haven't updated the agreement for quite a while, partly because we knew renters' rights was coming in. And so we're ready. And then when we start getting the information, okay, your statements must include A, B, C, D, then we can just make sure. We think most things are probably going to be in there anyway. But to give you an interesting thought, it is only a thought, in the Renters' Rights Bill, there is no mention of the How to Rent guide. Now, that to me seems a bit strange, that you would have thought, do they feel it just didn't work? But it seems unusual for them, particularly for a Labour government, to be taking away helpful information from a tenant that used to have to be given. It would sort of be downgrading it. And so I do wonder whether the statement, what I'll call a tenancy statement, will actually include the How to Rent guide information. But we won't know that until we see the regulations that say the statements must give this wording. So we'll just have to wait and see.
Okay. Well, I mean, and just for everyone's benefit, as soon as you've got the regulations and the documents are produced, typically it takes me a day or two to incorporate those into RentMan. That was what happened with the Welsh ones. I mean, it's quite straightforward, and then it's just, until I've seen them, of course, I don't know this for sure, but then it's just a click of a button to send it off via rSign or DocuSign to the tenant, the landlord, etc. Now, I'm confident you're going to be giving a lot of courses and webinars yourself on all of this and things that changes. Before we get into some of the questions that we've received, can I just get to give a very brief overview of how you expect the agents will have to change, especially when the tenancy starts, when rent is renewed, when a tenant gives notice, and when a landlord wants to get rid of a tenant. Just a quick overview of how you expect that that will have to change.
Well, the first thing I'm going to say is I actually think 95% of what we do every day is not going to change. And I am not, I would use the word panic-ridden by this legislation. The more you know about it, the less reason you realize there is to worry. We're still going to deal with repairs and doing referencing, that sort of thing. Obviously, we now have to give this statement rather than necessarily a tenancy agreement, though they may be integrated. So that's one point. There are a few rules around when we can collect money. The structure of that statement or tenancy is going to be different. We're not going to be allowed to do fixed terms. It'll have to be a monthly rental, or no more than monthly. It could be weekly, fortnightly, but no more than monthly. So in a sense, it's not going to be a lot different. It would be a bit like if you buy a new car, you're still going to be driving around doing much the same thing. It'll just be in a slightly different vehicle. So that would be my analogy. Rent increases are going to change because the basic rule is that all rent increases have to be done by Section 13 notices. We have a little strategy and wheeze around that. I'm not sure if we'll get time to explain it here, but we will certainly explain it on the training as we did last year. And nothing's changed for that. That still works perfectly. There is a recording of that on our website. When it comes to the landlord giving notice, my advice is don't if you can avoid it. Now, what I want, if I could just ignore the law, it's a really frustrating thing in my job that everybody thinks this is all about the legislation. The truth is that the more the law is not friendly to the landlord or agent, the more you don't want to rely on the law. So there is an amended ground 1 which says that the landlord wants to move back into the property or a family member. And you can serve 4 months notice. You can serve it at month 8. The tenant must have been there for at least 12 months by the time the notice expires. So you'd have to serve it at month 8. But when you've done that, you would then have to go to court, as you do now, if the tenant doesn't vacate. But if they do vacate, whether you've gone to court or not, you could not put that property back on the rental market, including sort of Airbnb, for 12 months after the expiry of your notice. So if you want to move back in there or move a family member back in there, you need to be pretty certain that's what you want to do. In fact, the analogy I was giving on courses last year was if my son separates from his wife, he comes to me and says, "Dad, can I live in the rented property?" And I go, "Yeah, that's fine." He moves in, and then he gets back together with his wife 3 weeks later. I now can't relet the property for 12 months. So what I'm probably going to say to my son is, no, you can't move into the rented property. I'll leave the tenant in there, but I'll help you rent a property somewhere else. You need to have that different way of thinking about it. Wait until their relationship is stable. If he gets divorced and they're permanently separated, now maybe we'll look at it because we know it's long term. The same with putting the property on the sale. The market is going to be an issue. You might not be able to sell, or at the price you need to get to clear the mortgage or whatever it is. And I think that the important thing here to say is you need to start thinking a lot more about people management and a lot less about legislation. Obviously, you need to know the law. We don't want to be breaking the law. But I would be going to a tenant and saying, look, I want to move my son in. He's divorced from his wife, and I want to move him in. Now, I can serve a formal notice on you for 4 months, and then I can go to court, and you'll have to pay the costs of my going to court. So that'll be £1,000, £2,000. But I think it'd be much better if you just started looking for a new house now. And as soon as you find somewhere, just go, give me a couple of weeks' notice, and that'll be fine. So then I don't ever serve the ground 1 notice. So then if 3 weeks after my son moves in, he gets back with his wife, I can relet it because I never served that notice. So serving the notice has become remarkably important or dangerous almost. And I think we need to avoid that where we can.
Okay.
The last one you mentioned, if I recall correctly, and you've given me about 4 things, and at my age, that's difficult to remember 4 things in a row.
Sorry.
The last one you mentioned was the tenant giving notice. Yeah. The most significant thing probably about a tenant giving notice is the law is changing to say that the tenant has to give 2 months notice. So that is an increase from normally a 1 month notice on a periodic monthly paid rent. It will now be going to 2 months. That is actually something that we recommended last year, that you might consider making that change immediately. So in other words, putting in your current agreement now, so all the lettings you do from now on, saying the tenant has to give 2 months notice. Now, the reason for that is because the transitional rules, i.e. switching from where we are now to the new system, say that the tenant has to give 2 months notice unless there is an agreement between the landlord and tenant to give less. So if you have a contract that says the tenant only has to give a month's notice, then they only have to give a month's notice, even though the basic law says 2 months, because they can go, look, but my tenancy agreement says 1 month. So you will have very old agreements that may well say month, and there's nothing you can do about it. But it might well be worth considering from now on, making sure that all your tenancies say that the tenant has to give 2 months notice.
I'll make sure that the rentman default agreements do exactly that, and then we just start. We start doing that right now for all the tenancies from tomorrow. Okay, that's good. All right. Well, thank you for that. Now we've got. We'll move to the questions that were sent in, and I've sort of ordered them in subject matter, but very loosely. And the first ones are all about that transition period, right? And Monica asks, have they indicated any start dates for this yet?
No, no, they haven't. There are a few interesting clues around. One of the proposed amendments in the Lords actually proposed about 450 amendments to this bill. Many of them were not pushed to the vote. Only about 8 were actually pushed through against the government's will. Of the 77 amendments from the Lords, most of them were the government proposing amendments because they'd realised they'd made some mistake. And in fact, they have corrected 2 mistakes. I flagged up 2 to them, and they've changed both of those now. But the one of the proposed amendments in the Lords was that would the government accept an amendment that said they guaranteed not to bring it in less than 3 months from it receiving royal assent. And the government refused to accept that as an amendment. Now, that's a slightly frightening phrase, I have to say, that they weren't willing to. They say they want to get it in as soon as possible, but they also say we'll give people enough time. I think what they don't understand is what do we have to do in order to have enough time? Every tenancy, etc., we've got on the system all has to be updated. And we can't even start that till we get the regs. So that's a little bit of a clue. It was interesting in the Commons debate yesterday that I would say the majority of speakers who spoke, they were talking more about how's this taken so long? Will you give us an undertaking? You'll bring it in quickly, and etc. Not talking about the amendments at all. They were all pressurising for this to be brought in soon. I don't believe it's likely to be brought in before January at the very earliest. Any regulations they lay would need to be there for 28 days. So that would basically be, even if it gets royal assent today, you're talking the end of November for the 28 days. So 1st of January, it could in theory start the 1st of December, but it would seem a bit more premature than I would expect. I think that would be very difficult for our market to accommodate. There's a lot of things we need to do. And it's not just at the agent level. If I step one further, which is very true for you, Nigel, of course, as you'll understand, is that this then needs to be incorporated into all the agents' software in order for the agents to be able to do things. So it's not just rewriting an agreement, it's putting it in the software. A lot of software is predicated on the presumption of a fixed-term tenancy. There aren't going to be any fixed-term tenancies, so we need to change all those sort of things around. And again, some of these we can't start changing until we at least see the regulations. I think once we see the regulations, we're okay on that. My best guess is that it'll probably commence around the March-April period. I don't think it'll be much longer than that. So that would be our best guess. Plan on April, but if it comes in January, don't be surprised.
Well, I'll try and get ready. I'll try and get Ratman at least ready by then. Monica again asks, what will be the first requirement to deal with?
Well, literally, chronologically, I suppose when I thought about that, the first thing is going to be you might be issuing a new tenancy on the day this commences. We'll call it the 1st of April as a commencement date, just arbitrarily. And from that day, you need to give out an agreement that's correct. It is an offence to give an agreement that says it's a fixed-term tenancy. It won't be a fixed term because the law doesn't allow it, but you'd be committing an offence by giving it out. So literally the day it goes live. The second issue that follows pretty quickly on the heels of that is that you will have a 1-month period in which to give I'm going to use the word a transitional statement to all your existing tenants. And this is going to be quite a big issue where your software can be of enormous help because you'll have all these people and they'll all need this statement, and it will be, what's the property, who's the landlord, what's the tenant, what are the tenancy terms? And so you'll have these statements, and they'll be unique. Each one will be different because the property is different, if nothing else. So each person will need to have this written statement sent to them within a month of the law going live. And if you've got 500 properties, you would not want to be manually having to create these, hence why, as I'm saying, the software will be your friend. And so the sooner you get on with that as well, if the process has been sorted, and this is why I'm saying, we need the software people to be on our side so that they're supporting us, and you will be ready then for the statement. You'll literally push the button and it'll stream off 500 PDFs that you'll send through DocuSign or whatever you're going to use. and job done. Now, they don't need to be signed. Don't confuse my statement there. That it's not that I'm asking them to sign, but I'm sending them via DocuSign because it gives me the evidence trail that it was sent and read.
Proof of receipt, yeah.
Correct. If they sign it, great. But if they don't, it's not a problem because I've got that proof of receipt. So that's got to be done within a month. And if you've got a lot of properties, you wouldn't want to be waiting till near the end of the month. It'll ruin your holiday.
Yeah, yeah, we'll get that done as quick as we can. Should we be issuing? Well, actually, we're already mostly there. The question is, should we not issue fixed-term contracts now and just issue periodic? Well, the standard training for professional contract is automatically lapses into periodic, doesn't it? So that really answers that question.
Well, it does in one sense, but we do start with a fixed term. So it's a hybrid agreement of the fixed element and the periodic element. Actually, you could start with periodics from now on. And in a sense, that would be less disruption because everybody from now on is beginning to understand the new system. I wouldn't have any problems with doing that. I think the only thing you just would need to watch is that obviously, I mean, under the new rules, then obviously the tenant can give 2 months notice the day they move in. They move in, give notice, leave 2 months later. And this is worrying a lot of landlords. I don't actually think there's a lot of justification because in my experience, it happens, but 99% of the time, the tenant wants to stay. He doesn't want to move out 2 months later. So I just don't think it happens in practice. If you were to switch now to periodic agreements from day one, in theory, a tenant could then turn around and serve notice and leave 2 months later, which the landlord may not be happy about. That would be the risk you'd have to factor in.
Okay. Let me just read this one out as I received it. If we are agreeing rent increases for new fixed-term tenancies at this stage, and fixed-term tenancies are replaced by periodic tenancies before the start of the proposed new fixed-term tenancies, can we issue just a periodic tenancy in place of the fixed-term tenancy that has been agreed? So the same as issuing a new fixed-term tenancy, however, on a periodic basis. I think
sounds like a tongue twister. That one does.
It does, but I think it boils down to the question, the answer you just gave.
It is very similar, but it also loops back to something I said before. You will be able to do a renewal onto a periodic. You're on a periodic, and I can do a renewal onto another periodic. Very often, this is aligned to thinking of changing the rent. So in other words, we'll end that tenancy, we'll sign up a new one at a new rent. My question is going to be, why would you do that? There are two reasons. One is obviously, I don't think the landlords are going to be happy to pay for this anymore because they're not getting any security or anything like that. But the second thing you need to understand is if you sign up the landlord up on a new periodic agreement, although the tenant can leave, having given 2 months notice, the landlord resets the 12-month clock. So we talked about earlier, ground 1A, you can't serve notice to take effect until the end of the first 12 months. That's 12 months of the current tenancy. So if you do a renewal, you've just reset and you've stopped the landlord being able to serve notice under 1 or 1A. Now, you can argue that there's an advantage in doing that because he can't get rid of the tenant and you still collect your commission. But of course, as his agent, you have a fiduciary duty to do what is best for him. And he would probably be within his rights to sue you and go, well, I wasn't happy with that. You only did it so that, you gained from it, not me. So I don't think it'll happen much, but it is possible.
Okay. Tom at Woodlands asks, very specifically, if a current AST expires in July 26 and has been on a 24-month term, and has not had a rent increase since the tenancy started, under the reforms, the fixed term becomes instantly null and void. Can the landlord increase the rent earlier than July?
Yeah, the simple answer to this is it's not clear. Nothing they've written at the moment in transitional provisions makes this clear. There will probably be further regulations that may clarify the point. The issue here is that in giving a 2-year tenancy without a rent increase, you have effectively agreed you won't increase the rent for 2 years. And so will they then say, okay, that follows through into the periodic agreement, because you agreed you wouldn't do it for 2 years, so you're still stuck to the 2 years. I can't say for certain. And as with all of these things in new legislation, ultimately we have to wait until a court goes and thrashes it out and makes
I
a
heard
decision.
I was ahead of you there because I slipped in a final question at the end saying everything we say here has got to be tested in court.
Yeah.
And, well, I might as well ask the question now. Is there anything in particular I couldn't choose a word. Is there anything in particular you think courts may muddy, clarify, and contribute when we get to it?
Yes, it is a tricky area. If I go back to the tenancy deposit rules, we were working with you back then. In 2010, so 2 or 3 years after deposits came in, I became unhappy about the issue of statutory periodic tenancies and prescribed information and all this sort of thing. And so that's when we introduced the hybrid agreement you mentioned earlier. Starts with a fixed element and then continues as a periodic. It's not a different tenancy, it's the same one. Therefore, you never had to give prescribed information again. Of course, in 2013, we had the Superstrike court case that said, no, statutory periodic tenancy, totally different tenancy, you should have given prescribed information. Now, we had managed by careful reading of the legislation, and I suppose you have to try and almost write the tenant's legal case to try and be as devious as you can and say, well, how can they possibly get around this and make mischief for me? And so we're always thinking in that way and then trying to put in place ways to prevent that happening. It's always hard to see what can go to court. Most cases, I think we sort of tend to see what's coming and try and prevent in some way. But the courts are free. And of course, if you look at a lot of cases, if you take the Rakusin-Jepson case about a superior landlord, Mr. Rakusin lost in the county court. He lost in the county court appeal. He lost in the court of appeal. He only won it when he got to the Supreme Court. So, you'd have thought all the evidence was he was going to lose it, but the Supreme Court took a different view, and it's incredibly difficult. Because some things will still work the same. I'll give you an example. We talked earlier about the tenant giving notice. They have to give 2 months' notice. This legislation does not say the tenant's notice has to end at the end of a period of the tenancy. But then again, protection from eviction, Section 5 never said that. It's a common law rule that if you have a periodic tenancy, your notice must expire at the end of the period. So I would expect the courts to say it's 2 months, but it must end at the end of a period, because historically that's what they've always said. Are they going to surprise me and go, no, since it's as long as 2 months, we think that's enough and you can go any day in the month? I don't know. I can't say.
I think the advice would be play safe and do it.
Correct.
At the end period. Yeah.
If you do it to the end, you can't be wrong. And if in 5 years the court say it doesn't have to be, then change the system. But you will never have been wrong.
Okay. Well, another one from Tom. He says the tenant pays 6 months rent in advance, which is next due in January. Under the reforms, can the landlord increase the rent in February despite the original tenancy ending in July under the previous laws?
Okay. I have to say I didn't quite get the previous tenancy bit, but basically the new laws very clearly only allow you to increase the rent once every 12 months. So either 12 months from the start or 12 months from the last increase, whichever it is going to be, we don't know. But you have a very, very rigid no earlier than the 12 months. You can serve the notice before, and the notice is now going to have to be a 2-month notice under Section 13. So you could serve it at the end of month 10 to take effect at the end of month 12. That's allowable. But the actual increase mustn't take place in less than 12 months.
And I think going back to just what you said before, even if legislation isn't explicit on that regard, you would expect a court and common law to carry over the previous periodic terms unless specifically contradicted somewhere.
Correct.
All right. I think you answered this earlier, but I'll ask it again just in case. And just a reminder to everyone, if you hear your question asked and you don't quite understand or the answer doesn't answer it for you, please do raise it in Q&A, and we'll revisit it. But when a landlord fails to sell a property after the tenant vacates, when does the 12-month waiting period start from?
Okay. The 12-month period starts from the expiry date of the notice, basically. However, the 12-month period is a bit of a misnomer, because actually the prohibition on reletting starts from the moment you serve the notice. So effectively, it's a 16-month period, because you've got 4 months during the notice plus 12 months after the notice. So in reality, that no reletting period is 16 months. Now, the reason that's relevant is if you serve, bearing in mind you've got to serve 4 months notice, if the tenant turned around the same day and counter-served their 2 months notice, they might leave after 2 months. And then you've still got another 14 months. So that's why I say in reality, the total period is really more like 16 months. And this is why I'm saying, if you possibly can avoid serving the notice, do it by negotiation. That has to be the way forward. I think that's really, really true for the sale ground. Yes, you can sell, but let's negotiate the tenant leaving. They leave, we put it on the market. If they're leaving because they found a new home, they'll be more inclined to let us do viewings. They'll be more positive about it. But most importantly, if the sale we thought we were getting falls through, or the price drops, goodness only knows, we've got a budget coming up shortly. We don't know what impact that's going to have on the property market. It might cause a bit of a dip. And all of a sudden you find you're caught not being able to relet for 12 months. Whereas if you didn't serve the notice, you're not caught. You can then immediately relet.
So again, you're saying try and avoid giving notice, if at all.
Absolutely. Absolutely.
How long can currently served Section 21 still be effective after the reforms come in?
Okay. Normally, you have a monthly paid rent, and it basically, the notice will be valid for a maximum of 6 months from the day it's served. That's the rule that exists today, and that carries on. But it will also only be valid for 3 months from commencement. So if you served a notice the day before commencement day, you'd have to wait 2 months. You'd then have 1 month to go to court. And then if you didn't go to court in 1 month, your notice would lapse. However, if you serve notice now, we're about 5 months away from the beginning of April. Your notice would run out in 2 months. It could sit there all the way till April, and then you'd only have 1 more month left of April, because it's 6 months from the date of service. This is actually one of the 2 errors I flagged up to MHCLG, because I said if you've got a 6 monthly paid rent, and we've already just had a question about a 6 monthly paid rent, a 6 monthly paid rent on a periodic tenancy requires 6 months notice. And I said, if you cut all these off at 3 months after the law starts, they won't have had time for their 6-month notice to run to the end. And one of the amendments that the Lords put back to the Commons that was accepted was a change to say that if the notice, Section 21 notice, has to be longer than 2 months, i.e. 6 monthly, quarterly, something like that, then you have till the expiry of the notice plus a further 4 months. So it's a little bit more generous, but broadly similar. So they've corrected that error that they had in the original.
Okay. Let me see, where did I get to? If a landlord is currently trying to sell a vacant property, which was previously occupied by a tenant, and decides after the reforms come into effect to relet, will they be subject to the 12-month waiting period?
Absolutely not, because that 12-month period is based on the service of the Section 8 notice, Section 8 underground 1A for a sale. There is no ground 1A at the moment. 1A is a new ground being inserted, so it doesn't apply. So if you didn't serve that notice, which is what I've talked about a couple of times already, if you didn't serve that notice, then you're not caught by the 12-month, and clearly this landlord wouldn't have served that notice.
Right. I'm sensing a theme here. With 6 months rent and advance payments, if a tenancy has already started, with the agreement being 6 months rent is paid in advance, Can we continue to collect the next 6 months instalment after the bill? Or do we have to allow all tenants to pay monthly, even though they didn't pass referencing, which is why they pay 6 monthly?
Yeah, I mean, it's an interesting point, and one I have been making when we were running the courses last year about this whole thing about paying 6 months rent in advance. Because I mean, the reason we do it is because we can't get certainty of somebody's financial position. That's a typical example. Maybe they've just moved into the country or something. I think that's something that's would needs to die anyway for a different reason. And that is when you had a fixed term tenancy, say 6 months, and you were able to serve notice and the notice expired at the end of the 6 months, then it made sense. Your noticeability and your financial certainty were both linked together, and you were therefore in step, if I could use that description. The problem you've got now is even if you could collect 6 months rent up front, you'd have no certainty, no way, literally no way of getting rid of the tenant at the end of that first 6 months. You know, they still haven't got a job or whatever else it's going to be. Nothing's going to change. And so I think the clue here is you need to look at, I'll use the word, your conditions when you take people on. You are going to need to be more careful. The harder it gets to get rid of people from a property, the less of a risk you're going to be willing to take. And that sort of is what you do when you take 6 months up front. You're trying to manage the financial risk, and you go, well, if they pay it all up front, I'll take that risk. But of course, now you have to assume they're going to be there indefinitely. So really, it has no value. Now, in terms of the actual question, I think there's a couple of bits. To be fair, it's not 100% clear in the legislation. If you have paid 6 months up front, and I'm going to choose some dates just to try and give context to the answer I'm giving. If you have paid for, say, on the 1st of January, you pay the rent from the 1st of January to the end of June. 6 month period, you've paid 6 months rent. No offence in that because you've paid it in January before the law started in April. However, when the law starts in April, there is a transitional provision in Schedule 6, Para 1, Subpara B, that basically says you don't fall into the new regime of monthly periodics until the end of the period that was running when the law started. So it will still run as a 6 monthly periodic till the end of June. It doesn't matter you collected 6 months rent up front, etc., etc. But obviously, going forward, you won't be able to collect the 6 months rent up front. You'll have to be collecting your rent no more than monthly periodic. You can do it weekly, fortnightly, 4 weekly. It's a maximum of 28 days or monthly. So you can do 7, 14, 21, 28, whatever you want, or monthly. And obviously, most people are going to go monthly. It makes a lot of sense, particularly around the rent arrears, because you can serve notice earlier on rent arrears.
Okay, great. We've got a few open questions have already been asked. I'm going to pause at this point and answer them just so that it gives people time to pose follow-up questions to these.
Yeah.
So Mark has asked, Mark, check your inbox. You owe me an email. Mark has asked, are guarantors going to be able to serve notice at any time too, like tenants?
Yes, they are, and this is one of the massive issues for us. And I'm very sorry that we've raised this right back to the Renters Reform Bill. Basically, there's a court case, Wingfield versus de St. Croix, from I think it's 1894 or something, in which the courts decided that if you are a guarantor on a periodic agreement, then you are able to give notice. The notice is reasonable notice. The reason for that partly is about guarantors. You sort of can't have an unlimited guarantee. Literally the guarantor could be in this for the rest of his life, and he doesn't really know that. And there are real problems around guarantors. So first one, change in rent. So you let to somebody, and we don't know it when we let to them, but let's just pretend they're going to end up being there 5, 10 years. The only way you can change the rent is to serve a Section 13 notice, which imposes a rent increase on the tenant. But the law, as far as a guarantor is concerned, is that anything that increases their risk means that they're not a guarantor anymore unless they've agreed to it. Now, you can go to the guarantor every time you want to serve your notice and say, we want to charge more rent. Do you mind increasing your guarantee to cover this higher rent level? But if he says no, you can't increase the rent. They could be there for 5, 10 years and you couldn't get any rent increase because you either got a rent increase or you lose the guarantor. Which is it going to be?
Well, I'll live without a guarantor. I remember having long conversations with you many years ago because there was I sensed a huge discrepancy with what the letter of the law required for guarantors and the way that people were actually using guarantors.
Yeah.
And the contracts, guarantors were off the hook in many practices.
Well, and this is the problem we've got now because you sign up a tenant and a guarantor, and the day the tenant moves in, the guarantor writes and says, "I'm giving notice." And if I was a guarantor, that's what I would do. My kids are past university age, so I don't get the opportunity to play that game with somebody. But if anybody who knows what they're doing, they will agree to be the guarantor, and then they'll just write in afterwards and say, "I'm not the guarantor anymore. I'm giving notice." And you've lost them. And I think the issue here is you need to think more carefully. I could see this as being what I'll call a good sales point for commercial guarantees. What I mean by that is there are certain companies where you can buy a guarantee rather than go to an individual. Now you're sort of more into contracts and things like that. So you would do it on that contractual basis. So there are a number of problems. One is the ability for them to give notice. The other one is you can't make any changes that increase their risk and they're still the guarantor unless they've signed up to agree to it. So it's going to be really difficult. And I know what's going to happen, and this is the madness to me about this whole piece of legislation, is that this is going to be to the disadvantage of the less well-off tenants. The very people who should be being helped and supported are going to get absolutely shafted by this. If you earn £200,000 a year, this is not going to cause you any problems at all.
No. Another one from Mark. How about serving a notice that looks like it's in a prescribed format, but isn't? So that it looks like it's the official request and hopefully will get the tenant motivated to leave. Bosh, non-prescribed format and stick it back onto let.
Yeah, I don't know whether they've already thought about, Mark, in this, but in the legislation, there are actually offences for using the wrong form, and there are offences for claiming a ground without a reasonable belief that you have the right to do so. This is going to be important. But if we go back to sort of normal Section 8 as we might use today, we might claim rent arrears, but they may be under, say, 2 months, so it's a ground 10. And what we would tend to do at the moment is throw the kitchen sink, and we'd go, well, yeah, a neighbour did complain about some noise once. I'll add antisocial behaviour, and they've got a goldfish and they're not supposed to have pets, so I'll add that on as well. And under the new legislation, if you are claiming a ground without a reasonable cause to do so, if I use that word, then that is an offence. So using the wrong form is an offence too. So we will need to be very careful. And in fact, I didn't mention it. You were asking about the agreements. Currently, and we had this, do you remember those days of COVID and we were talking about MHCLG during COVID kept changing the Section 21 notices. And I kept saying, no, Parliament has not issued a new form, because at the moment, to change a Section 8, Section 13 or Section 21 notice needs Parliament to approve a set of regulations. Now, one of the changes the Renters' Rights Bill is doing is it is taking that away from Parliament and giving it to the Secretary of State. So the Act says that Parliament will agree that the Secretary of State can produce the form. Now, my concern around that is that the Secretary of State can produce the form at the drop of a hat. We wouldn't know. Just Monday morning, all of a sudden, there's a different form on the website. And if we use the wrong one, we're committing an offence. And I would have liked to have seen some sort of safeguards. They had to give you 4 weeks notice or something of that nature. Whereas there is nothing in there at the moment. Now, whether something will come through in the regulations is not clear. It's also worth saying there are quite a long history of cases around forms, prescribed forms, they tend to use language along the lines of or a form of a similar effect. And so if you try and do this and you don't make it exactly the same as the prescribed form, you may lose anyway because they'll say, but it's to a similar effect. So that would be your danger. If you make it look like that, they'll say, well, it's near enough. The tenant understood you wanted possession. You committed an offence for reletting. And I will add that one of the things, as well as being an offence, so in other words, you can get a penalty for it. First offence up to 7,000, subsequent offences up to 40,000. The tenant can also claim the last 2 years of their rent back, which could be an even more expensive penalty. So probably not a good idea to try and do that, would be my recommendation.
All right, so Mark, we don't want you being tested in court. Play safe.
No.
I think is the quick answer to that. Diana asks, what is to stop you from putting the tenants on a short-term holiday let agreement instead, since it is now only monthly?
Yeah, well, I mean, there is an issue around the holiday lets because certainly people in London where there's a law saying you can't let for less than 90 days, of course, you've then got this problem that you could find holiday let people say, well, okay, we're coming to London for 6 weeks, we'll rent a property and day we move in, we'll serve notice and move out. And that could well happen. The issue around the holiday let, I mean, the first thing to say about holiday lets is you can only do a holiday let if somebody's on holiday. They need to have another main residence where, all their important posts, they're registered on the electoral roll, their driving license, all this sort of stuff is registered. If they're not genuinely on holiday, it won't be a holiday let. I mean, this really sort of goes back to the Street versus Mountford case where they described, they talked about if you have a 5-pronged digging instrument and you call it a spade, it doesn't make it a spade just because you call it that. It is whatever it is. It's a fork. And therefore, it's much the same here. It would only be a holiday let if it was a holiday let. The issue of international students mentioned in the question is really significant. People are talking about different things around student lettings. Student lettings, it's a huge issue on its own right because they're now going to go monthly. And I've spent over an hour with somebody on the phone this morning doing student lettings because, as I've tried to explain, they start their student year in September and they take a fixed term 12-month tenancy to the end of August. I've suggested that they want to move that date back to end of June, July. Now, the reason is if the tenant starts on the 1st of September and they're running monthly periodic, they may well only have 2 days at uni when they've got to do exams during May, June. So they'll serve you notice and they'll leave at Easter, say mid-April. You've then got the property empty from mid-April till the beginning of the next September. Because there's nobody in it, it's a property the landlord will have to pay the council tax and he'll get no rent. Now, obviously that's desperately unattractive. You can't stop it entirely, but if you move your start date back to the beginning of July, then at least you've only lost April to July's rent, whereas obviously then it's let to the new people who can't sort of pull out because they want it from September from the date in July. So students is a big issue in their own. Now, internationally, it links into our discussion about guarantors. First of all, guarantors abroad. Are you going to go through the Siberian county court system to try and enforce a judgment against some guarantor? Probably not. The obvious thing we've all done for years is you collect 12 months rent up front. Oops, we can't collect 12 months rent up front anymore. We're limited to only 1 month at a time effectively. It is true, before the tenant moves in, you can only collect 1 month's rent. They must have signed up for the agreement, and then you can collect 1 month's rent. And then, 1st of January, that is, say, then 1st of February, they pay you February's rent. 1st of March, they pay March's rent. All that sort of thing is absolutely fine. The tenant can choose to pay you the whole 12 months on the 1st of February if they want to, but you can't in any way demand, require it, ask for it, or anything else. That would be an offence. And I'm wondering with the overseas students whether one solution, again, we'll have to see how it works out, but we're wondering about the idea of whether with overseas students, you actually let to the parents, not to the student. Because the parents are probably going to be the guarantors anyway, and they're probably funding it anyway, let's be honest. Now, the reason this is important is that if we let to the parent, it is not the parent's only or principal home. Therefore, it can't fall within the Housing Act 88. It becomes a contractual tenancy like a company let is. Therefore, we can collect all the rent up front. Therefore, we can give a 12-month fixed term as well. So that's our thinking around that particular area. It doesn't break anything in the Renters' Rights Bill. It would be open to a challenge, and I did hear a solicitor saying he's really enjoying listening to all these discussions because he's looking forward to getting paid for arguing all these cases in court.
And there was something else that occurred to me as you were speaking there. I mean, you can't, the agent can't demand or require 12 months in advance.
No.
The tenant can offer and can pay 12 months in advance.
Yeah.
But is the agent then in slightly awkward situation if after a couple of months the tenant gets some legal advice that says, oh, but that wasn't rent, that was a deposit, and you haven't registered that deposit, and therefore you're in trouble? I mean, is there a big risk there?
There is definitely a risk. In fact, I'm going to say the only case that we know of where our tenancy has been all the way to the Court of Appeal is actually a case called Johnson versus Old. Somebody was using our agreement. They had slightly modified the rent payment clause in a way that we wouldn't have recommended, which I believe caused the problem. But they talked about the rent for the first 6 months being, say, £6,000, and then the rent would be £1,000 a month. And the tenants claimed in court that therefore 5 out of those 6 months were a deposit because it was due monthly, it said, and therefore it was being paid as a deposit. The landlord was able to successfully defend it on the basis that the agreement said that the rent is payable 6 monthly for the first bit, and the monthly reference was to after the fixed term, because, as you mentioned earlier, we did the hybrid agreement, fixed term and then monthly. So the reason it talked about the monthly rent was post the fixed term. Now, the problem is, of course, now we're not going to have any fixed term, so the rent is not due. So the question now is the legal definition within the within the deposit legislation, the Housing Act 04, of course, is any money held to ensure the tenant fulfills an obligation. Now, there may be an argument to say the tenant asked to pay this early, and therefore I'm not holding it to ensure they did it. They wanted to pay it, and I'm holding it because they didn't want to hold it. I didn't ask for it, and that may be an adequate defense. But again,
we'd want a court judgment on that.
We're in uncharted territory. Yeah.
Okay. I think there was one more. No, I think it's already been answered.
While you're just reading that, I can see there's one here. Can guarantors give notice if the tenant is in arrears? And of course, the answer is yes, they can. It doesn't get them off their liability for those arrears that have already accrued, but from the expiry of their notice, they'd have no further liability. And indeed, that's probably one of the times they're most likely to give notices, because when you start saying, we want you to pay, and they're going to go, well, I'm off, thank you.
Yeah, quite. All right, well, back to the to the original questions we had. Amy, with tenants having a right to 12 months in a property before notice can be served, i.e. to sell, if a tenant swap takes place 6 months in, does the 12 months reset?
Yeah, this goes back to our previous discussion about the periodic agreement and the presumption that most of the current legal framework will carry on. The current legal position is that you can't change a tenant on the tenancy. You can change a lot of things, but there are some you can't. You cannot extend the length of a tenancy. That will create a new contract. You cannot change the tenant on the tenancy, and you cannot increase the demise. In other words, if I rent to you the first floor of building A, I can't add floors 2 and 3 to the first floor and on the same contract. It has to be a new agreement. So the change in tenancy is effectively a new tenant, because I use the analogy here of a football team. We don't, I try and use the language properly because it helps explain some things. We talk about tenants in the plural. In fact, we should correctly talk about a tenancy and the tenant. Even if there's three people, it's
Jointly
one
and severally liable.
tenant. Absolutely. Their liability is inseparable. So I use the analogy of a football team. We use the Liverpool football team, not teams, it's singular, because there is only one team, even if there's 11 players. Now, in the rental world with three sharers, if one leaves and another one moves in, that's actually a composition of a different team. We wouldn't say the English football team are the same team as won the World Cup in 1966. They're a different team. They're still the English football, but they're a different team. And in the same way, when you get a change in the sharers, I mean, you could end up over time with nobody who was there originally. So when you get a change of tenant, the law says that is what's called a surrender and regrant by operation of law. In other words, the law imposes that that's a new tenancy. So you've got to do things like deposit protection, how to rent guides, all those sort of things. Now, in the question of the Renters' Rights Bill specifically, that will restart your 12-month period because that's a new tenancy. And even it's the same tenancy. Any new tenancy resets 12 months.
Again, there's a difference here between the letter of the law and the way a lot of people work. And I've had this conversation many times over the years, regardless of this legislation. In practice, agents try and avoid creating a new tenancy because it's just a like for like. We've had this conversation before, and then you get into problems of, well, who's got the deposit and
Absolutely. And I think this has implications around the statement too, because if the statement has to state who the tenant is, and Fiona's left and Michael's moved in, now your statement is wrong.
So I think the answer to this question is, or generally, is that this legislation then makes it, and the penalties, if you get it wrong, makes it much more important that you do actually create a new tenancy if you try and if there's to be a tenant swap.
Yeah, and let's look at it the other way round as well, Nigel. And that is to say that if you're going to create the new tenancy, that it should be a chargeable event against your landlord. You're having to do work, and therefore why not?
Yeah, and you sell it to the landlord as being, you've got to stay on the right side of the law here.
Absolutely.
There are penalties. All right, well, let's move on. There's a couple of questions about pets coming up. Under the new regime, RRB, regarding pets, if a building's head lease requires a pet license and there is a fee for the license, can this cost be passed on to the tenant that is requesting a pet? Would the Tenant Fees Act class this as a permitted change fee? If it was at the start of the tenancy, would this actually class as a change to the tenancy?
Yeah, that was a very interesting, the last point. So let's deal with those in, because we've got a couple of questions. Scenarios built in there. First of all, it's not really RRB. The question, as is identified in the question, is a Tenant Fees Act question. And clearly, if the tenant wants to make a variation, then absolutely. If the freeholder is going to charge you £50 for giving consent to have a pet, then absolutely that's something that the Tenant Fees Act allows you to charge. I do think there's an interesting, I suppose the word almost is question here. If I go to a viewing and I tell the letting agent, look, I've got 3 dogs, I'm probably going to find I'm less likely to be chosen to rent that property. So in practice, what I think is likely to happen is many tenants will say they haven't got any pets. And then a week afterwards, they'll go, I'd like to have my 3 dogs, please. Because now that they've got the property, I can't turn them down. And I cannot unreasonably refuse. Now, 3 dogs may be too much for that property. That may be the case. But I can.
Unreasonable needs defining, doesn't it? Or
yes, it will to some degree. I mean, there is a difference. You may be aware, of course, in the whole Renters' Rights Bill, there's 2 elements of what we would call discrimination. So it will become a specific statutory offence to say no DSS or to say no children in the property, with what I'll call limited exemptions to that. It is not an offence to say no pets in the property. So the rules around pets are different from the rules around benefit claimants and children. And so it is actually perfectly acceptable to say no pets in the property. But that won't stop the tenant moving in and asking, and you can only reasonably refuse. And again, we will probably have to have a few cases go to court as to what's reasonable. Now, one of the importance about it being different is if the head lease says no pets, that is enforceable. So in other words, you would be able to say, no, you can't have a pet because the head lease doesn't allow them. If your head lease says no fixed, you can only let on a fixed term tenancy, then that is overridden by the renters' rights legislation.
Right. Also regarding pets, can you please give some examples of accepted reasons not to accept a pet? For example, not enough outside space for a dog.
Yep, that might be true. We use this word very loosely, and I've never been a great fan of it. Our agreement doesn't say no pets. It might say no cats and dogs and no other pets without consent. And as soon as you say without consent by law, it can't be unreasonably withheld anyway. Because I've always held that if a tenant said, well, can I have a goldfish in a bowl? You've got this question about, well, is it reasonable to refuse? And obviously not. I think the reasonability of the pet is going to be very true. You've got a big St. Bernard on a fourth floor studio flat. You might say, no, that's not reasonable. There may be other reasons. The head lease is definitely going to be your first one. And don't tell anybody that I told you this, but we have a little sneaky idea we're thinking around that actually, if as the agent, you do a rent to rent, if you know what I mean by that. In other words, you rent the property off the landlord and you sublet it. You could set up an agreement with the head landlord that says no pets. And then when you sublet it, your superior lease does not allow you to have pets. So if you've got a landlord who's very adamantly against pets, I can see that might be one way to get around it.
Interesting.
Untested in court, and I make no money from going to court, I will just add. But I can see that follows the letter of the law.
Okay. Interesting. Another example might be, certain types of dog and small children in the building or as neighbours.
Absolutely. I was on a meeting around HMOs last night, and you can see if you've got 7 sharers in a house and one of them wants to bring in, a banned breed, shall we say, something like that. Clearly, you're going to go, well, I don't feel that's appropriate, or children, or anything of that nature. You might, if the landlord, if this is the landlord's own home and he's temporarily away, you might also get away with allergy issues. If it's an investment property, I don't think you would, because the landlord doesn't have to go there. But if it was his own home, that might be another reason. If he's only away for, say, 6, 12, 18, 24 months, reasonably short term.
Okay. Well, another one from Mark at Wade Residential here. If we serve notice on a tenant for a rent increase and they do not agree to pay, and we exhaust negotiations with them, what will our options be? Can we refer it to the tribunal if the tenant does not? If the tenant does, and the tribunal awards a rental figure, and the tenant still does not pay the increase, will it be a case of simply waiting for the rent arrears to reach 3 months and then issue possession proceedings?
In simple answer to the question, yes. It's not that the rent is 3 months late. It is that the value of rent arrears is equal to 3 months. A lot of people are hopping up and down on this one a little bit. Although interestingly, in 1988, and I was letting houses before the 1988 Housing Act, but when the Housing Act 1988 came in January 89, you had to have 3 months arrears for this ground. It was only the 96 Act that dropped it down to 2 months. So we've actually only gone back to where the Act was originally drafted as. So, it isn't really that. And let's be honest, this is not having to wait 3 months. This is what I would call broadly 2 months and a day. Because if you say the rent is due on the first day of every month, it's not paid the 1st of January, it's not paid the 1st of February, it's not paid the 1st of March. On the 2nd of March, you've got 3 months of rent lawfully due and unpaid. So it's only really 2 months that you're waiting. This is one of the reasons for doing monthly, not weekly. Because if you do the maths on weekly, you've got to wait another 3 weeks before you can serve that notice. I also see... I see people potentially using ground 10 more because obviously that's any rent arrears, not necessarily 3 months. So people won't wait to get to 3 months. They might say, well, okay, let's start that process earlier and just go on the discretionary ground. You can always ask the court to add ground date later. So you know that they have the power to if they want to. And even if they won't give you an outright order for possession, you still have the option to ask the court to give you a suspended order, i.e. they must pay the current rent plus 50 quid off the arrears. And if they don't pay the 50 quid off the arrears or the current rent, you can immediately go and get the bailiffs and evict. So it's always worth going that way. And I just think some people may do that more. There's a whole discussion. I think you need to think very careful about your rent process. I've got plenty of time here. I'm not a problem for me, but we are teaching a different way of doing the rent increases. I actually have been saying when we ran our renters' rights bill course last autumn, I was saying I think the rent increases is the most important part of this legislation, not the loss of Section 21, because I was involved with the Letting Industry Council, and I ran a survey for them of letting agents across the country, and we found out the information about 95,000 Section 21s that had been served in the previous 12 months. And the question we asked was not only did you serve notice, but why? And the reason I wanted to know why, and I have shared the results of that with MHCLG, so they're aware of this, that the reason I was interested in it is because I know that this is just a complete joke. When I'm talking about on courses, I say, do you think landlords wake up one morning and go, what haven't I done for a while? I haven't served notice. I'll tell you what, let's kick a tenant out. I mean, it's laughable. You know, landlords never evict tenants without reason. And that's what
I can think of a couple I used to know when I was a lettings agent. But anyway, carry on.
But they'll have a reason. They don't do it for no reason. Maybe they just don't like the tenant, but it's still a reason. Now, when we did this 95,000 survey, what we found was I think it was half a dozen would not have had a reason under Section 8 to serve notice. Most of them were rent arrears, antisocial behavior, wanted to sell the property. And all that'll happen, you hear this repeated by Shelter time and time again, that the single biggest reason that people turn up at a local authority homeless is because a landlord served a Section 21. I was in a meeting yesterday, I think it was, and they said 32% of the people who turn up homeless, the biggest single reason is a Section 21. What I'm going to give people a guarantee is that following the Renters' Rights Act, the biggest single reason is going to be a Section 8 notice. It isn't going to stop landlords who've got tenants in arrears seeking possession, or they're being antisocial seeking possession. They're just going to use a different notice.
Section 21 wasn't the reason. That was just the mechanism. There was an underlying reason, right?
You didn't have to give. And again, they said it in the Commons yesterday, listening to it, and it makes me laugh. I wish I could have spoken in the Commons. There were so many massive errors there, just ridiculous. But the point is that they were campaigning to ban no-fault evictions. That's the language you hear all the time. And I'm going, well, why is the tenant at fault if the landlord wants to move back in or to sell the property, or the mortgage lender repossesses, or it's a minister of religion? We haven't banned no-fault evictions at all. It's a complete lie.
We're getting towards the end now for anyone who's looking at the clock. Glenn, Church and Horse, we have never served a Section 28, never had to, and are quite nervous about this. We're in a liaison and agreed with a local firm of solicitors to do these on our behalf. Do you think this is a good idea? The solicitors will charge the landlord for this. And we assume any agent that does issue the Section 28 will also charge for the service. We feel this will get us up and running when the changes come in to avoid any disasters. But moving forward, we may well decide to do these ourselves in the future. I'm going to add at this point that when the new documents arrive, Rentman will have a new document, so we'll have a new Section 8. It will have been tested, and I would expect Rentman to produce a valid finished document at that point. That said, I wouldn't discourage anyone from confirming the validity with their local solicitor until they've at least built up a level of confidence. What are your thoughts around this?
Yeah, I think, I mean, obviously that's always very hard. I'm going to go a little bit broader in my thought. The first thing I'm going to suggest is what we actually provide a service in training for professionals where we will do the notice service for you. So you just give us the information, you fill it out on a spreadsheet, and we will produce the notice and serve it by post for you, or we can return it for you to hand deliver if you want. Now, we've been doing that for some years. We do it with Section 21 and Section 8 grounds. But what we still say to people is, look, you need to make a judgment here. And we refer to this business as property management. I started training professionals back in 93. In 97, I think it was, we ran a series of courses which we called Property Management, the Truth. And the whole point behind it is that the truth is this has nothing to do with managing properties whatsoever. This is a people management game. And what I'm going to say you need to do is you need to make an assessment of that individual. If I serve them notice, are they likely to just move out? Or if I serve notice, are they going to dig their heels in and go and get shelter lobbying on their side, go to the council? We all know that if they go to the council and say, oh, I'm being homeless, I want a council house, the council are going to look to undermine us and to take out our notice. So my view is that if this is somebody who's likely to relocate themselves, you might choose to serve the notice yourself, and it's never really going to go to court. It's just a formality of giving them that choice. And so I would be quite happy to do that. If, on the other hand, this is a real barrack room lawyer type individual, and I definitely need to be careful about this one, I'm going to say I would get the solicitor who's going to go to court to serve the notice. And this is even more true around Section 8, because whereas Section 21 was very few boxes to fill in, Section 8 is a little bit more subtle and nuanced. They were antisocial, but is that antisocial enough to justify serving notice or not? Mm-hmm. Even down to how the evidence is collected. Is this hearsay evidence, or is this actually first-hand knowledge? There's all these things going on. So if you think this is definitely going to go to court, for your own safety, and again, you might want to check as an agent your own professional indemnity insurance. Are you actually insured for serving a notice? Because if you're not, you wouldn't want to find you had to pick up the bill. Just think of how this is now going to work. You've served 4 months, and and I've done this the other way around, where friends have contacted me, and I've seen that their notice is wrong. And I've said to them, well, don't let the agent know that the notice is wrong, because they wanted to stay beyond the notice until it gets to the day before the notice runs out, and then tell him it's wrong for this reason. So you've waited 4 months. The day before they turn around and go, no, you've done this wrong. And if this is rent arrears, the landlord might have lost another 4 months of rent arrears. And now we've got to start the whole process again. Who's he going to blame? We need to understand that and be really careful about what we're doing. So in essence, care is definitely, and we are a little bit, not entirely, a little bit back to square one, understanding these new rules, because the rules are different. If you think of what we have, there's a slight anomaly that I'll flag up in the Renters' Rights Bill. We know that deposit protection is carrying on. So if you haven't done deposit protection right, you will not be able to serve a Section 8 notice. At the moment, that's linked to Section 21, but not Section 8. Under the Renters' Rights Bill, it will be linked to Section 8, with the exception of the 2 antisocial behaviour grounds, grounds 7 and 14. So we know that the deposit rules are, I'll use the word, moving across. Curiously, the Renters' Rights Bill makes no reference to having given an EPC or a gas safety, which of course are requirements for a Section 21 notice. So are we to believe they're lowering the standard compared to Section 21? I suspect we're going to find all of these things are going to come through in the regulations. So I just don't believe they're going to downgrade the security. I think it'll be in regulations. So we don't even know all the rules at the moment. So it's very difficult. And until people get used to the new rules, I think absolutely be very, very careful what you do. But even long term, if this is going to be contentious, my view is get the solicitor to serve notice.
Right. And just picking up on your original point there, the solicitor who's going to take it to court for you.
Yep.
And hopefully that is then someone who is a specialist in lettings law.
But it's a psychology point. If the judge says, I'm not sure this notice is correct, a solicitor who has served it will fight tooth and nail to argue he did it right. If you did it, he may go, yes, Your Honor, I was a bit worried about it too.
Okay. All right. So, but, and the follow-up question to that is, and I think we've answered it already, you will be running courses on correctly completing Section 8s, and you even offer the service to issue them yourself, right? And you and I will talk about having the agent generating something to send you out of Rentman directly. So their version of the Section 28, which you can then tweak.
Yes, no, we actually do it at the moment in a spreadsheet, an Excel sheet, but there's no reason that couldn't be exported, a lot of it, not all of it, because you may not, for example, why do you need this notice served is not necessarily going to be built into Rentman. You'd have to type that box in. But obviously the landlord's details, tenant's details, all of that is going to be very simple.
I can always pop up dialog boxes. The reason I like to do it out of Rentman is it's there in the history 3 years later.
Yep. And you don't have to retype names and addresses and make mistakes, because we always do things like we check the postcodes and the addresses are correct and all this sort of stuff, because by law for court work you're required to use postcodes. So if you get it wrong, they can turn around and go, it's the wrong postcode, it's not valid.
Okay. Well, I've got 2 more questions outstanding, and then I've got a general point I just want to bring up. But just to clarify, you cannot stipulate that the student has to pay 6 months up front. Can the letting agent tell the student before the tenancy is made that the landlord would only consider offers where the tenant pays 6 months or 12 months up front?
No, you can't.
Yeah, I think you answered that. No, you can't.
No, absolutely not. I mean, you're trying to sort of get round the rule, but I'm afraid that getting around doesn't work, in my opinion. In other words, essentially you cannot ask them to do so. That's really what you're doing in that statement.
Right, and I think, and Kevin, I think we've already answered your question, which is that it's about 3 months rent outstanding, not when the last payment was made. But so Kevin Michael asks, if a tenant owes 3 months rent and in court they pay £1, the court would then not give possession, and they can repeat this time after time, costing the landlord money each time with no repercussions?
Yeah, effectively, the answer to that is sort of yes, but there's another failure at play here. The first thing to say is I do know of a case where this exact thing happened. It was obviously 2 months' rent, and they tried to pay some off in court. And the legal definition for Section 8 is that they must owe you currently today 2 months of rent arrears on the day you serve notice and the day of the court hearing. So when the tenant turned up and gave the agent or landlord £10, the judge said, yes, but on the day of the court hearing at midnight, you still owed it, you're evicted. But if they did it the day before, you have to accept it and you will duck. Now, this is the teaching around Section 8. I would say you never, ever serve a Section 8 Ground 8 notice without including Ground 10. Ground 8 is the serious rent arrears ground, currently 2 months to be 3. But Ground 10 is any rent arrears. So if they pay you off the day before £10, and bearing in mind you've got to give them a month's notice, they may do that. In fact, if they go to Shelter will say you need to beg, borrow, or steal this money to get below 3 months of rent arrears. Then you won't get evicted. Now, you've included Ground 10, and you say to the judge, you're quite correct, Your Honour. And even the way we teach to fill out the form allows you to immediately remove Ground 8 and just get left with Ground 10, so that it's really easy for the judge. These guys like to get out and play golf, so it's important we make their life easy for them. And so we teach you how to fill it. And we would always say, if you're going on Ground 8, include Ground 10. Tenant pays off that £1 of arrears. You go to the judge and you say, well, Your Honour, he's paid me £1. He's £1 under 3 months. So Ground 8 fails. Completely accept that. But we have asked for Ground 10. Can we at least have a suspended judgment on Ground 10, i.e. they've got to pay the current arrears and the current rent and £50 off the arrears. The minute he fails to do that, you can go straight to the bailiffs. You don't even need to go back to court for that.
Excellent. Okay. Well, I've got a final question here, and I'm going to change the original question because I think it can be, your answer could be wider for this. The original question was about the right to rent checks, but the general point I think that it brings up is what obligations does this new legislation change for the lettings agent, especially for let only? So the question was, do we need to do right to rent checks every year or after an expiry date? But the same would apply presumably for EPCs, gas safety certificates and everything. I imagine for management, the agent takes on the obligations of the landlord. But for let only, does the agency have any continuing obligations around right to rent and certificates and so forth?
Yeah, I think there's a few things around this one. It is a tricky area. The first thing I'm going to say is that it's really important in your terms of business to be clear what you will do. And the way I always ran this when I was a letting agent many, many years ago, we had the quill and all that sort of stuff in those days, was the fact that you either signed up to one of our standard services, i.e. you signed up on full management or let only or whatever else it was, or if you wanted anything that was non-standard, you had to list what you wanted me to do. So there was never any ambiguity, because if you didn't say that you wanted me to do the gas safety, I wasn't liable. So just watch that one, because it's very easy for people to go, well, I'll just do the repairs. And it's not clear who's doing what. So that clarity of who's doing what is the first thing. And of course, my view is if you're not being paid for doing the gas safety or whatever, why would you be doing it? The second point is on let onlys. I suspect that it's certainly what we've seen in Wales, both since Rent Smart Wales started, which introduced landlord licensing and agent licensing, but also under the occupation contract. It's quite a number of older landlords have actually said, well, this is just too difficult to learn a whole new system, just give it to the agent to manage. And I think it is possible that whilst I think we will probably lose some properties, I can also see that some landlords will be going out to agents and asking the agent to take over letting the property.
I'm hearing that from customers. Yeah, I am hearing that.
And that's the good thing. And I think an important part of this, and this is again what we were doing last year, is I was saying, look, you need to be out communicating to your landlords, reassure them this is not the disaster everybody says it is. But the more professional and more well-informed you appear to be as an agent, the more likely it is the landlord will say, well, you seem to know what you're talking about. Now, the pitfall that I think people walk into here is that it's not their responsibility to get a gas safety, and they start writing to the landlord saying, just to remind you, you need to get a gas safety. Because if you start doing that and then the landlord doesn't get one done, he may turn around and go, but you didn't tell me. Every other year you've told me it was my responsibility. So you've sort of created an expectation. So in my view, you make it very clear. And we had a letter we sent let-only landlords at the point we handed over. We'd moved the tenant in. We're handing it over to you. Please note, you need to get another gas safety done by this date. You need to get this done by this date, et cetera, et cetera. There's a sort of letter I'm sure that Rentman could run off very easily, pulling those dates out of the software.
Well, it actually sends out those reminders automatically as the expiry comes due, if the agent has chosen to.
I would not be sending it out what I'll call routinely at the end of the year or whatever else it is, unless we're managing the property, because I would not want to be starting to assume the liability for having. Because if I've told you, am I then culpable if you don't do it? Because I didn't make sure you did it, having reminded you.
Yeah.
And my view is if the landlord doesn't want to pay you, why are you spending your time and effort doing it?
Well, it is an option they have to switch on. So, okay, I've got one final question to ask, and then I think we need to wrap this up.
Yeah.
The main reason we use Section 21 is rent arrears or antisocial behaviour, and the council is on our back. How are we going to prove antisocial behaviour? The issue is we can get penalties from the council for antisocial behaviour from the tenant, but then we can't get rid of the tenants as we don't have a witness, etc. What kind of evidence can we use? This is the main worry.
Yeah, and this is. But I mean, first of all, the beginning of that statement proved my point. The main reason we use Section 21 is rent arrears or antisocial behaviour. Obviously, rent arrears is simple. You've got the evidence. Antisocial is a really difficult one. That, by the way, on Section 21 is one I would say, Section 8, I would say is don't touch. I have a friend who is a solicitor, and he specialises in this with housing associations, registered providers, and at times he's ended up, employing 2 ex-SAS soldiers to dig into the end of the neighbour's garden to gather evidence for antisocial behaviour. It gets to that extreme level because none of the neighbours around the antisocial house are willing to testify for very obvious reasons. It's interesting, in the renters' rights, one of the recognitions, and this is at its worst in an HMO. So you go to court, and the 5 people in an HMO, and 4 of them are suffering from antisocial behaviour from one of them, potentially violence, threats, etc. And then you all end up in court. These 4 are going, no, he's horrible, and then they've all got to go back and live in the property again. I mean, it's just beggars belief. And the renters' rights actually does slightly change this to say that the judge must have greater consideration for the other people who are, having to share that property. It's very difficult. In social housing cases, the member of staff from a local authority is allowed to go and testify without needing the actual individual, which you might argue is hearsay evidence, but they do allow it from local authority staff. Sadly, they don't tend to allow it from us. We should be able to go to court in the same way and say, look, I've had 15 complaints from neighbours in the neighbourhood about loud motorbikes roaring up and down the road at 3 a.m. in the morning, rather than each individual neighbour having to be named and I'll use the word exposed, potentially, to a risk and a danger. Now, the first thing is that yes, you can serve notice. The council will struggle to take any serious action against you if you have done everything you're able to do. The fact that the court wouldn't give you possession is a perfect defence. We tried. We served Section 8. We went to court. We didn't get possession. The court didn't feel our evidence was good enough. Yes, there's a cost involved. I don't disagree. But I go right back to what I said earlier, that the harder it becomes to get rid of people, we need to be more careful about who we let in the first place. And that's what's going to happen. I think we're going to lose a percentage of rented properties, and I've heard all sorts of figures. I read one just the other day, about 20% they were saying we'll lose. But if we lose 20% of properties, we can probably afford to be even more selective about who we choose to put in. And we need that. That is our number one defense. Any other focus, you need the best person in your organization to be vetting and dealing with those applicants, because that's your number one filter, is who you let in the first place. If you don't let them in, you'll have none of these problems in the first place.
Okay, great, thanks. All right, well, I'm going to wrap it up here then. Thank you so much for this.
You're welcome.
This has gone on a lot longer than I anticipated, but thank you. I would just urge people to attend your courses and webinars. The Training for Professionals website, there's recent versions of RentMan have a link to it under the help toolbar, so you can go straight there. David publishes frequently what webinars, what courses they're running, and what is upcoming. And I think it's beholden on everybody to attend these and get as much information as they can before this happens. You'll also, I take it, be publishing, you mentioned before this started, that you're monitoring the government website to see when things are happening. So presumably you'll be reporting that on your website as well, will you?
Even whilst we've had our webinar, the government website is updated, because I checked earlier on the webinar and it wasn't. It was still the hourglass was still on the consideration of the Lord's amendments. That's now got a tick, and the hourglass is on royal assent, and that's literally happened whilst we've been on air. So yes, we watch it all the time. We do put bits of news on the website. So yes, that will be there. What I'll do, if you're okay with it, is when we don't know, we're as ready as we can be. We've literally got half-drafted mailers ready to go, but we can't send them out until we know the content. So you want to know, well, what am I going to learn if I come on the course? And some of that's in the regs. And I daren't advertise a course, and I've seen several courses advertised that are starting. One of them's next week. They don't even
I
know if
saw
the
that too, yeah.
they don't even know if the regs are going to be up there. So
Yeah.
we're having to wait until we find the regs to be able to give you that best value. And therefore, as soon as we get that, I'll send you the mailer if you want to let other people know. If people want to contact the office, we are actually running a list. We've got over 300 people who've already said they want to come on it. Can we tell them when it's going to be? We're quite happy to add you to the list and contact you once the law goes out. But we're
And
totally
I'll be sending you
ahead.
the people who registered for this as well, so that you can you'll
Yep.
have anyone who doesn't want to be included on that list. I suppose GDPR. Tell me now, because I'm just going to export the what Zoom has gathered for the registration and send it on to you. And of course, I'd urge everybody to look at my blog as well, which again, there's a button in Rentman on the help tab. Because I'll be publishing anything I think relevant as it unfolds and as we go through. And of course, support is always there to help. All right. Well, thank you very much, David. Thank you for that. We'll be talking soon, I'm sure. Thank you, everyone, for attending. Look for this on the YouTube channel. Thanks. Bye-bye.
Thank you. Bye.